Hello again, my name's Stephen Carris and welcome to LBS Legal TV. I'm joined as usual with Chris Kirkblythe, CEO of LBS Legal, who usually has quite a lot to say. And today I would imagine it's no different. Chris, welcome back.
Thank you.
I had to say that or else I would be out of a job. Today's show is a very important subject and Chris is going to tell us a bit more about it in a moment, but if you are a personal injury lawyer, you should pay close attention to the following discussion because obviously the subject of today, if you hadn't gathered already, is personal injury law. And Chris, can I just ask you, what prompted you to dedicate an entire show, bearing in mind we've got a whole hour to get through, to personal injury law?
Well, it's specifically risk in personal injury law that I thought we should do a show on. It's been something that I've been thinking about for a while because there seems to be so many different issues which are relevant to practicing personal injury. What swung it was that I was in a hotel lobby in Manchester 3 weeks ago just for a meeting, and I happened to be sat behind another meeting which was taking place in the lobby, and I wasn't deliberately eavesdropping, but I couldn't help overhearing these three chaps who were discussing a new business venture. And that business venture was a company that they were setting up with a specific intent of going after personal injury solicitors on various grounds.
Really?
So, this is not me saying this, but I'm just going to tell the audience the types of comment that I overheard. So, for example, the meeting started by somebody saying, that we believe that the personal injury sector is a profoundly dysfunctional sector or part of the legal services community. Dysfunctional primarily because for a few reasons, but I think the thing they seemed to be focusing on was that the way that personal injury firms are structured, which is usually one or two kind of partners, directors, managers, or sort of senior people, usually qualified, usually 10 years experience, etc. And then a bank of paralegal, junior, non-qualified fee earners, very little experience, very young, and of course that model may be necessary financially, but it comes with a lot of issues and problems in terms of how do you get young, inexperienced people to consistently produce good standard of work in a technically complicated field. So the belief of these guys, and I mean I don't know who they were, and I don't know how serious they are, but they sounded credible, they sounded serious, and they sounded well resourced, and it sounded like this was going to be a significant venture. And they were saying, look, within the personal injury arena, the lawyers are not having face-to-face meetings with their clients. They're not really getting to know their clients. They don't properly understand medical reports. The people who review the medical reports don't have the experience. They're consequently undersettling lots and lots of claims. And even to the extent where partners are putting pressure on junior staff to settle claims quickly, perhaps too quickly than is wise. So one thing that we do know is that along with the other firms that we've seen recently making a play for this kind of work in terms of bringing negligence claims against personal injury solicitors for undersettling claims, which is a big growth area. We know there's another player about to enter the market in Manchester who's going to do this on a serious scale. Undersettlement of personal injury claims, by the way, has been an issue of concern to the senior underwriters within professional indemnity circles, who, of course, we talk to regularly. They've been concerned about this for, I would say, 2 years now. The claims numbers are increasing, and it is an issue. And personal injury solicitors need to be reflecting on the risk to their personal injury to their professional indemnity premium. On the whole, the professional indemnity market is softening slightly. We're in a cycle where things are getting slightly easier, but I think the personal injury sector may be the one sector that bucks that trend, and I think over the next few years things may get tougher for personal injury solicitors, traditionally considered to be low risk.
But this isn't something new though, is it, Chris? I mean, we know that for a long time now the personal injury market has come under a lot of scrutiny and a lot of criticism, and former Home Secretary Jack Straw has been highly critical of the cash for crash culture that's prevailed. So are you surprised that this come to this, or is this just something that...
The issue of undersettling claims is not new, no. What is new is the focus that various businesses are putting on. Businesses have realised that they can make money by acting for accident victims whose claims have been undersettled. So there are new business models that are arising. We're starting to see marketing activity. In towns in West Yorkshire, there are people going around council estates, knocking on doors, saying, have you had a personal injury claim in the last 6 years? If so, we believe we can get you some more money. Sign here and we'll look at it for you.
And I understand these guys also talked about unlawful deductions from client damages as well. Is that correct?
Yes, that was a big part of their conversation. They believe, as do I actually, that the majority of personal injury firms are not doing the correct calculation when it comes to the fees that they're entitled to charge their own clients, the amounts that they're entitled to deduct from.
Just so we're clear though, we're talking about unlawful, not just a little bit of sort of cutting of corners, but we're talking about unlawful deductions, so very serious stuff here.
By unlawful deductions, I mean a deduction from client damages that the law does not permit the solicitor to make.
And yet this is quite common.
Well, I believe it's happening on a fairly wide scale, and so did these chaps who were discussing this new business venture. So I thought what might be helpful is, I certainly don't intend to give a full lecture on the Jackson reforms because it's an 8-hour topic. But I thought I thought perhaps if I just talk through the correct calculation for a fairly standard RTA claim which settles at stage 2 of the portal, and hopefully in doing so firms will realise whether or not they're making broadly the right calculation.
RTA claim being a road traffic accident.
Yeah, so just a straightforward road traffic accident. It never leaves the portal and it settles at stage 2. So I'm just going to talk through what the correct calculation should be.
Okay.
So step 1, you must time record on the file, and you must know what your costs are, what your hourly rate costs are, and you must work out what the total costs are that you've run up on that claim. What is your work in progress, in other words? So let's just say, for example, that sum is £2,000. So step 2, add your success fee to that. A lot of confusion about the correct percentage for success fees. As a starting point, your success fee should be 100%. So 100% of £2,000. Forget about 12.5%, forget about 20%. 100% is fine, and I'll come back to that in a moment. So your success fee, therefore, is £2,000 because that's what your base costs were. Then have a look and see what your client's damages were. How much damages were your client awarded? And for the purposes of this calculation, it's only general damages and past pecuniary losses that you can take into account. So that's sort of one common mistake, just taking the entirety of the damages that have been awarded and using that figure instead of the correct figure, which is the entirety of generals plus past pecuniary losses. So okay, let's assume that that's £3,000. Sorry, just before I go on, something that happens fairly regularly is a defendant will make what's called a global offering, a global offer to settle a claim. So they'll get their heads of claim, there'll be generals and specials and various other things, past and future pecuniary losses, and the defendant will say, right, let's just forget all that, here's a global offering for you. If you accept the global offering, how then do you know what proportion of that sum consists of generals and past pecuniary losses? The answer is you have to use your professional judgment to make a reasonable calculation, and you have to inform your client of the basis on which you've done that. You don't have to get your client's advance agreement, but you do have to explain in your closing letter, probably attached on your cheque, that this is the calculation that you've done. So you determine the amount of general damages, and let's just say that's £3,000. Well, then your success fee is capped at 25% of that. So we said your success fee is £2,000, but you've got to cap it at 25% of the client's damages. So that's £750. So that is your success fee. £750, by the way, is inclusive of VAT. Do not add VAT onto the £750. £750 is the total amount that you can deduct from the client's damages. So that's all fairly straightforward, but there are a couple of complications that are of fairly serious concern, I think, and there's a degree of ambiguity about the point that I'm going to make. This is not something that's been settled before the courts, but it's something which, in the view of LBS, having looked at it very carefully, we are quite clear on. And here's the complication. What I would like any personal injury solicitor to do is to look at Section 58 of the Courts and Legal Services Act. That's the part of the Act which defines conditional fee agreements. And if you look specifically at Section 58 brackets 2 brackets B, you will see that you can only apply a success fee to, and this is in quotes now, the amount which would be payable by your client. The amount which would be payable. And this is where there's a lot of confusion. Because if you say to your client at the outset of the retainer, in your retainer letter or in your terms of business or in your CFA or in any of the papers which contain the contract terms between you and your client, if you say to your client, you, Mr. Client, will never be responsible for our hourly fees. You don't have to pay that. All you will ever have to pay is what we recover from the other side. Well then, if you're saying that to your client, then the only amount which would be payable, in accordance with Section 58, is the amount that you recover from the other side. And that, as we all know, in a Stage 2 settlement in the portal is £500 plus VAT. So even if your costs are £2,000 on the clock, you can't use that figure because your client, that figure would not be payable by your client because you've already agreed with your client at the outset that that would not be payable because you've told him. So what can you apply the success fee to? Well, you can only apply the success fee to the amount which would be payable by your client, £500 plus VAT. Therefore, your success fee is 100% of that, £500 plus VAT. And that's the maximum that you can take from damages.
So lots of firms' damages entitlement is effectively capped at 500 plus VAT.
Correct, because they are not making it clear to their client that their client would have to pay the entirety of their costs on an hourly basis, which makes things extremely difficult because we all know that if you said to the client, right, wherever there's a shortfall between our hourly rate and what we recover from the other side under the fixed recoverable costs regime, if there's a shortfall, then you, Mr. Client, you have to pay that shortfall. For a start, if you said that to a client, you would have no client because they would go somewhere else. Secondly, if you intended to carry through with that, what you'd have to do to your client is advise your client, in many cases, not to bring a claim in the first place, because it would not be in your client's interests to bring a claim because they'd probably end up owing you money. And they'd probably end up with no damage, or certainly very little. And on a risk-reward analysis, it just wouldn't be worth it. So we're left in a very unfortunate position where what you have to do is make it clear in the contract documentation that your client is liable for those hourly costs, but then never charge the client for them. And somehow tell the client outside of the retainer documentation that you don't intend, or that you never have before, charge the client those hourly fees. A very difficult thing to do. It requires extremely careful drafting. But if you don't get it right, let's be realistic. Let's call a spade a spade. You are overcharging your clients. You're deducting unlawful amounts from the client's damages, amounts which you're not entitled to. In regulatory or disciplinary terms, that is culpable overcharging. It's possibly even dishonest overcharging. It's a serious regulatory matter. It will see you before the tribunal. It will also merit complaints against you to be upheld for the legal ombudsman, and negligence claims to be upheld. You'll have to make repayments back to clients, maybe on a massive scale, maybe over hundreds of cases. You know, it's possible that this is the next sort of PPI scandal about to happen, but this time around, it's not going to be banks; it's going to be firms of solicitors. So it's absolutely crucial that solicitors get the documentation absolutely right. There is another complication. I said that 100% success fee is always going to be fine. That's debatable. You may not be able to charge a 100% success fee. If, for example, you're dealing with a passenger claim and there is no risk or a 1% risk that the claim will fail, you know, can you justify a 100% uplift on your success fee when there's a 1% risk? Well, there's nothing in the conditional fee agreements order of 2013 which says that you can't. But bear in mind, Civil Procedure Rules 46.9 brackets 4. Again, have a look at it. I'm not going to read it out to you, but I think when you've read it, you'll see that if your bill is ever challenged and assessed, you will have to justify to the court why you charged a 100% success fee. So you must be able to justify that. So does that bring us back to a situation where you have to carry out risk assessment on each case prior to opening it? Probably not, but you need to be broadly aware that your position may be challenged and it's got to be defendable. Which, last point on that, given that this calculation process is complicated, given that so many firms are getting it wrong, the big question becomes who within your firm is making that calculation and who is checking it. Because in my experience, fairly junior paralegals are making the calculation and all they do is this: how much were the damages, what's 25% of that, done, right? It's more complicated than that. So they're doing the wrong calculation, then they're giving an authorization slip to somebody in accounts department, nobody checks it, accounts department processes it, nobody even sees it. So that part of the process now, it needs to be checked. It needs to be checked by somebody who understands the calculation properly. Right. On every claim.
So on a matter of checks, supervision if you like, something that you've mentioned a few times in our discussion so far, do you have any particular tips that you could give to one or two partners in how they could best supervise, for example, paralegals in relation to claims?
Well, I think it's been an issue for a long time because for certainly for the last 10 years, the basic model in most personal injury firms has been to have a heavily systemized, computerized system managed by one or two individuals and operated by a team of fairly junior people. I think post-Jackson and post-LASPO, because the financials have become under a bit more pressure, that model is becoming a sort of intensified version of itself. Fewer people at the top, more at the bottom. That means the few at the top have to manage lots of people at the bottom. Well, I have fairly controversial views on managing people. I've read lots of books on how to manage, lead, inspire, etc.
Could you share one of those controversial views, please?
Well, my controversial view is this: I don't think it's possible to manage people. I think people are uncontrollable. I think they're irrepressible. I think they're irresponsible. I think they're unpredictable. I think it is exhausting trying to manage even one person.
So your birthday parties must be very quiet, quiet affairs.
Well, I don't try to manage people at my birthday party.
Good job.
But management is extremely, extremely difficult. And what law firms need to do is something akin to what McDonald's have achieved to do. McDonald's get what I'm going to rather rudely call muck staff, junior, inexperienced.
Can we just say sorry that a rather famous burger chain rather than just McDonald's, just so we don't get into trouble.
Trust me, McDonald's will be pleased with what I'm about to say.
Yeah,
because what McDonald's manages to do successfully,
the regulator wouldn't,
is to turn out the same consistency, the same quality on a predictable basis, so that clients or customers know what they're going to get, and they get it every time, and they get it with high staff turnover, unskilled staff, low skilled staff, junior staff, unreliable, unpredictable, individuals who come and go after 3 months, who, you know, and this is something that McDonald's is proud of, by the way. So I don't really agree with you, because they make a point of this. You know, this is in their promotional literature when they're selling franchises.
So we're not going to get sued by them.
In their promotional literature, they say that we have managed to come up with a formula whereby we can take, you know, young lads who smoke dope at lunchtime, and we can still get them to turn out a good product time after time. Well, how do they do that? Well, they don't do that by trying to manage that person. They do that by creating strong, rock-solid systems that work. And okay, running a personal injury claim, slightly more complicated than making a burger, but it's the same principle. You've got to build, engineer, calibrate, design, implement a system that works every time, that works predictably. Because, you know, I don't believe you can manage people, but I do believe you can manage a system. So for every aspect of a personal injury claim, there needs to be a way of doing it. You know, this is how we do this here. This is our system. This is our system for taking a witness statement. You know, we're not going to rely on you to be sensible, because we don't believe that employees are consistently sensible. We know from bitter experience that they're not. So we're not going to trust you to be sensible. We're not going to rely on you to be sensible. This is step 1 of taking a witness statement. This is step 2. This is step 3. You cannot deviate from step 1, 2, and 3. You must do step 1, 2, and 3. And it, you know, if I've got a tip, which is what you asked for, that's the tip. Don't try and manage people. Build a system and try and manage a system.
Thank you for that, Chris. Very concisely and succinctly put. And just for the record, LBS Legal does not advocate the smoking of dope in lunch breaks, particularly if you work at a popular fast food restaurant chain. Just moving on then to our next point. Sadly,
I'm not sure it's even called dope anymore, is it?
I don't know.
No, we don't know.
I've never touched this stuff. Okay, now onto a more serious note. Of course, sadly, from time to time, law firms do unfortunately fail. And I just wondered, you know, in your experience, Chris, do you have any? Can you share any stories of any firms that have unfortunately come to an abrupt end?
Yeah. Well, it's an unfortunate aspect of my job that I do get involved in these scenarios where firms are failing, and where they do fail for a whole host of, you know, financial and business reasons, or, you know, maybe regulatory or disciplinary reasons. And yes, I think, you know, I'll give you some examples. Quite recently, we saw a law firm in Leicester fail because of disciplinary action, because that firm was using unpaid professional disbursements to fund salary bills. Not in any kind of dishonest way, more in a desperate sort of way, in ducking paying certain bills so that they could meet the salary bill. And let me just be clear to the owners of law firms out there how that is viewed in regulatory terms. If you use client money for anything else which is related to your own interests, such as paying your own salary bill, you know, you will not be given any leniency. You might as well take that money, you might as well steal that money and go and buy a Lamborghini with it. You know, that is how it's viewed. It's not your money, it's client money. And unpaid professional disbursements are client money. You cannot use that money to pay salary bills or anything else, no matter how important you think it might be. We've seen a firm in the East End of London go bust. 3 solicitors in the personal injury department, 1 very trusting partner and 2 very lazy assistant solicitors who were running effectively what I think were just artificial caseloads. They were just telling the partner that they were really, really busy, that they had loads of cases, and their files were an utter shambles, a complete mess. There were no merit in the claims. Most of them should have been shut down years ago. The WIP figures which the firm were operating on were an absolute fairy tale, complete fabrication. There's no integrity in the WIP figures at all. Irresponsible management in terms of interrogating the WIP on a regular basis never happened. So, you know, that's another example. I'll tell you a quite bizarre example which is recent, and it's an important point for all personal injury firms to note. The Ask MID system which I don't need to explain to this audience, but which is obviously a critical tool and something that you need to rely on and use.
Just in case there weren't there were non-lawyers watching, what's an MID?
It's just a process by which solicitors can check the insurance company of a driver of a particular car. But law firms have an agreement with Ask MID, and most of them don't know what that agreement says. But if you breach that agreement, Ask MID will terminate it, and that will, as I've seen recently, destroy a firm. Advice: look at clause 1.1 of your agreement with Ask MID and look at how worryingly and frighteningly broad their cancellation rights are. Look at clause 4.1.16, which makes it clear that you can't share your password. And in fact, if you give your password to a colleague within your firm, they will cancel your agreement. The most important one, probably clause 4.1.11, which is when you enter variations of registration numbers or accident dates under the system. So
car registration numbers.
Yeah, so you're not quite sure what it is, so you try 5 or 6 times.
Yeah.
Now, if that happens once, that flags up on Ask MID's system, and they will ask you to explain that.
So they can tell you've been searching for a range of...
because they suspect there may be fraud. Usually, you've misheard your client, or your client's got a very strong accent, or your client can't quite remember, and you're just trying to help your client as best you can. That sort of thing. Yeah. Or you can't read your own handwriting, or But be scrupulously careful. And what you're obliged to do if you do search on the wrong registration number is notify MID, tell them that you've just made a mistake, and that'll be fine. But if that just keeps on running, you'll just get a letter saying you've been switched off. It's terminated.
In this instance, was it a training issue, or was it?
I think the firm concerned were just completely.
Was it?
No, they were just completely unaware of their obligations, and they just thought this was a system that they could use however they wanted, and they didn't take any notice of the terms. So look at the terms, specifically the terms that I've mentioned. More dramatically, and probably more tragically for the owners of the firm concerned, we've seen in very recent months 2 firms fail because they were infiltrated by criminal gangs. It's a complicated story which I don't have time for, but just, my advice is be extremely careful, because there are people out there who are junior paralegals who have been tapped up by criminal gangs with a very sophisticated scheme which involves running fraudulent claims through firms without the firms knowing about it, off-site. Very clever, very sophisticated model. The police are involved. But the extent of due diligence and checks that you have to do on your paralegal employees is now pretty extensive, because there are these guys out there, you can't spot them. Some of them have been paralegals for 4 or 5 years at good firms. You won't know there's anything the matter. But there are a whole series of checks and balances that need to be in place really to catch those people out. So just they're the last 4 firm failures that I've been involved in. Funding your own firm using unpaid professional disbursements, having a completely fabricated whip on your books, taking no notice of your obligations to Ask MID, and being infiltrated by criminal gangs at a junior paralegal level.
Something which probably affects, I would say, 99 if not 100% of our viewers working in that practice area. Well, thanks very much for that, Chris. I'm sure it's been very helpful. We're just going to take a quick break now. Join us after the break, and we'll be continuing our discussion in relation to personal injury issues today. And I'll see you in a few minutes. Thank you.